Like I said, my name's Diane Letarte, and I started with this maybe 6 years ago. I wanted to do criminal work. I did some criminal cases on the outside, but kind of found a niche with the post-conviction and doing a lot of these parole hearings. What I want to do is maybe a little unusual. I want to take you into the boardroom of these parole hearings. And so believe it or not, where you're sitting at right now is very, very similar to where I spend half my time, in prison, in a room that looks a lot like this. I represent the inmate when they go to what we're called their parole suitability or unsuitability hearing. And I meet with them probably anywhere from 2 to 6 months before they actually go into the board. They call it the board. The Board of Parole Hearings is it used to be 3 commissioners that used to sit and listen to basically the inmate recount the crime and try to convince the commissioners how they are now suitable to be released back into the community. What I want you to do is just to think right now that you are in prison, either for first-degree murder, second-degree murder, kidnap, rape, kidnap, robbery, whatever the life sentence was. You've been in there, if it was second-degree murder, 15 to life. And you get to come up probably after you've been in 12 or 13 years. You're looking forward to go into the boardroom to show how you're suitable and you can be released. So what then happens is a lot of them are nervous. A lot of them have basically the initial board meeting, and a lot of them don't know what to do. When I was appointed as on the panel, I would get anywhere from 10 to 15 cases a week where I would go to the prison with the files. There's a central file in the prison, but as the attorney, I get a subset of that central file, and I have to review pertinent documents. There's usually a psychological report, anywhere from 5 to 20 pages. There's usually what's called a board report, which is also called a life evaluation report or counselor's report. And it's basically every one of these inmates have a counselor, and they provide information to the board in a format that's maybe 10 pages long. And then there's other portions to that packet. That's the discovery that we get. It has a lot of the court documents. If there was an appeal, there's usually a record of the appeal, the abstract, the sentencing, the charges that they had, and the parole agent's report. Reviewing that document, the documents that I received, I then set up to go speak with my clients. You have to get clearance way ahead of time to some of these prisons. Sometimes you get there and it's not like going to meet with a client in a regular office or in court. You get there and sometimes you might sit there. Definitely all the correctional officers are on a different track. You'll get there and you might wait an hour or 2 hours before you see a client. Some institutions are better than others. Some institutions would allow me to interview 5 or 6 or 7 clients back to back. I would normally take a couple hours and speak with my client and basically set them up for what's about to happen if it was their initial hearing. If it was a subsequent hearing, what I normally do is there's a transcript. Every time you have these little mini trials or these little hearings, they're administrative type hearings. They are recorded, and the inmate will get a transcript of that hearing. So if it's what we call a subsequent hearing, then there is a transcript. In discovery time, when I get what I call the attorney packet from the institution, at one point, and some institution would actually give you the whole transcript of the prior mini trial or hearing that occurred, which is very, very helpful. It'll tell you where the commissioners are coming from, why they denied him. Very, very helpful. What the institution has been doing now is only giving me part of that transcript, which is the tail end of the transcript. So what happens is you have the whole parole hearing, which is, they try to schedule them 2 hours apart. So it started at 8:30 hearing, at 10:30 hearing, at 12:30. There's no lunch. You just keep going until 5 o'clock, 6 o'clock, 7 o'clock. You do about 2 hours if you're state appointed. In between, you'll have private attorneys that come in, and those hearings might stretch from 2 to 4 hours to do the hearing. But the documents that I received from that hearing on the transcript, they have started to only give me the decision portion of the hearing. And what that means is when you're in the boardroom, which is very similar to this, you'll have the two commissioners up here, you have the inmate, I'll be next to the inmate, you have the district attorney there, either live or through video. And on some occasion you'll have what we call VNOCs, which are victims next of kin or victims. Then the boardroom gets a little full. But the very tail portion of the transcript is once you present it and you did this hearing, everybody is excused out of the room, and the commissioners will deliberate whether your client is suitable to be released or not. And then you come back into the room, and then they will read their decision. That's the portion now that they're handing me. They're only handing me the tail end of this hearing, which is usually about 10 pages long. So what I want to do is, one of the sheet that you've received looks like this. It's my table of content of what I call, and you'll get a copy of this, is basically the tips for the inmates. And what I've done is I've repeated myself so much that I put a document together for the inmates. I was asked to speak a couple months ago at the families of the incarcerated. Families were saying, I want to help my loved ones. What do I do? How do I support? I understand I have to write letters for them as part of some evidence that is produced during the hearing, as far as a place for them to live or even a job offer. So what I did is I put this tips together, and like I said, you'll get a copy of it, but what I did is I just pulled out the table of content. So what I'm going to do now is just walk through pretending that you're all my clients. And I'm going to meet with you and basically give you the scoop that I give them to present basically at the board hearing. Some of the main questions that I get are, do I speak about the crime? And what's recent now, ever since the Lawrence and, how do you pronounce, Shaputis case, which came down in 2008, is insight. That becomes a big buzzword. So how do the inmate present that they have insight into their crime? The other portion that I go through with them is post-conviction factors, and that is everything they've done since they've been incarcerated. So I review with them what the board is looking for. Parole plan is something that all my clients, I tell them we're going to go in at this hearing. We're going in as a team. Let me do the legal stuff, but you have to bring in your life and you have to bring in everything you've done. So that's part of the parole plan that they need to work on, and they have documents that I tell them to put together so that when we go in there, we only have 2 hours. And believe me, 2 hours to tell somebody's life at 20 years or 15 years of incarceration is not a lot. So I usually prepare them and say, look, this is your job. You can do this. You do the legwork. You go down to your central file. You pull all your certificates and everything else. So I usually tell them this is what your parole plan are going to be. And then a lot of time they'll get the board report and they'll get a psych report. And they'll get a copy of that. And they'll say, well, what do I do with that? Well, and this is part of the things that I go over with them is what do you do with the board report? What do you do with the psych report? There's a section here on Lawrence and Shaputis. And then I usually don't like to speak legalese or law stuff with them, although some of the inmates probably know more than I do. So those I will entertain speaking the law with them, but most of the time I won't. I will just try to set them up so that they're prepared for the actual hearing. One of the main things that everybody's on board now, the inmates, even if they don't know anything about the law, they want to know about Marsy's law. That is such an impact on them nowadays. So I will usually take quite a bit of my time to speak to them about Marsy's law, because there are a couple of strategies that we can do before we go into the board that is directly related to the fact that Marsy's law is effective. It's been effective since I think the board started at December 2008. And then I just have a little section. I tell them things to remember, kind of, be a person and remember commissioners are just people. So there's a couple of things that I tell them how to communicate with the commissioners. Lastly, on that table of content is a section that I kind of beefed up a little bit because I did another presentation that I mentioned before. I was invited to families of the incarcerated, and that section was prompted by the fact that, like I said, the parents or the wife or the husband wanted to know what do I knew from the outside to help him on the inside. So that's kind of like the bullet items, this table of content of what I want to speak about. If I go back to the crime, so I will basically sit with my client and they'll say, Diane, do I speak about the crime? And my answer to that is it depends. It depends on the crime. It depends if this is your initial hearing. It depends if how your demeanor is. I will look at my client. If he's one of those clients that can't talk his way out of a paper bag, most of the time it's like there's no sense in trying to speak about the crime. When you do start the board hearing, the way that they start is basically everybody introduces themselves, and they will ask if my client is speaking. They'll swear him under oath. And then at that point, I will usually indicate to my client or to the board, I'll say, I've advised my client not to speak about the crime. And that has been more and more so since the Lawrence case. One of the things the board articulate at the very beginning is you're not required to talk about the crime. We're not here to retry your case. And of course, they go right into retrying the case. So one of the things that I like to do is direct the hearing. The way that I do direct the hearing is I advise the commissioners that my client will not be speaking about the crime. This is not why we're here. We're here to talk about all the post-convictions and everything he's been doing since he's been incarcerated. So talking about the crime, I tell them it really depends. I will give them usually the 2 or 3 months before the actual hearing. I will tell them, okay, this is my gut feeling. I don't think this is one of those cases that you're going to be speaking about it. I don't think you're, comfortable in articulating this, and there's no reason for you to talk about the crime. But I always tell them, the day of the hearing, I might change my mind. We might have no district attorney show up, no VNOCs show up. We might have a good panel. And at that point, I might say, you know what, we're going to be speaking about the crime because it's a good panel to do it. But most of the time I don't. But like I said, it's just one of those, I can't describe it. It's like one of those things that I go off my gut feeling the day of the hearing. So there's, like I said, a lot of questions, and I even get a lot of letters from the inmates saying, Diane, you represented me before, and I'm coming up for board, and I've got, one of my writs is up on appeal, and do I go to the board, and do I speak, or what do I do? And it's not something I can answer in, a letter. It's something that you have to analyze a lot to decide if that's the best for that particular case. So whether they speak about the crime or not. The insight, which is something that's been talked about a lot because of the case. So if they do not speak about the crime, I'll tell them that they can speak about remorse and insight, and it's very crucial that they do. Now, certain clients, I won't even go there with them. It's kind of a hard call, because if you start talking about remorse and insight, you might go into the crime. If you open that door, then some of the commissioners will say, okay, well now, we can discuss and ask questions about the crime. And one of the reasons that I prefer not to have my client talk about the crime is because there's already in the parole, the